So this part will be on chapter 27, the liability for environmental offenses. So, environmental protection. It includes the protection of air, water, and land pollution. The purpose is the preservation of natural resources, the acceptable use, transportation, and disposal of dangerous goods, and also the assessment of environmental impacts due to activities. The regulating bodies or the environmental offenses are regulated by the municipal, provincial, and federal government. The corporation role. The Canadian Environmental Protection Act of 1999 and corresponding provincial statutes creates a strict liability offenses for corporations, directors, and officers when the regulations covered under the Act are breached. The only defense for the offenses established are due diligence. The corporation must demonstrate that there is an effective system in place to prevent the offenses that have occurred. The system must have also been monitored and improved if problems did occur. After the offenses do occur, the ones charged of an activity are found liable. They must persuade the court that a person charged in fact had the effective powers and responsibility. This is what makes it difficult since a director would have the effective powers but only attends a couple meetings a year. So they rely on reports from environmental staff and others. So would they be liable if they weren't part of it and they only saw the reports? The law is not intended to punish innocent and reasonably diligent people. Punishment. In general, corporations are fined according to the seriousness of the breach or of the harm caused. Directors and officers receive small fines, but in extreme cases may be sentenced to prison. Now we'll go on to the Westray mine for the case study. So an overview. The underground mine opened on September 11th, 1991. It was owned and operated by Curragh Resources Incorporated. The mine closed in 1992. So a summary of the disaster. An explosion occurred in the Southwest 2 tunnel at 5:20 a.m. on May 9, 1992, which killed 26 miners. The continuous mining machine created sparks, which ignited the methane. High level of coal dust created a massive explosion. A 10-day search and rescue operation followed, which they only recovered 15 of the bodies. The contributing conditions. The ventilation system was found to be inadequate, causing a buildup of methane in explosive concentrations, since the ventilation was not able to sufficiently evacuate the contaminated air to the surface in safe concentrations. Methane is a dangerous pollutant found in coal and is released during the mining process. Explosive in concentrations between 5% and 15% by volume in air. Coal dust conditions were also very bad. Coal dust is flammable and needs to be treated with stone dusting to neutralize the coal dust explosives in nature. Section 70-1 of Coal Mines Regulation Act requires operators to clear or treat coal dust to render it non-explosive. Some early signs before this disaster. In the first 2 months of the mine's production, there was 4 roof fails. The Nova Scotia Department of Labour expressed concerns about training and certification of the workers. They had a lack of emergency plan. The mine was given a special permit to use potentially dangerous methods to tunnel to the coal seam without mining coal by the Labour Ministry. The Nova Scotia Labour Minister, Leroy Laguerre, was not aware the company continued to use those methods 3 months after opening to mine the coal. One miner complained about safety issues to the Labour Ministry inspectors, which they did not investigate afterwards, and the miner was later fired. The Department of Labour was concerned about the failure to deal with the coal dust by stone dusting or removing of the coal dust. So there's a provincial government appointed Nova Scotia Supreme Court Justice K. Peter Richard was to conduct a public inquiry after the disaster. The report stated the mine was mismanaged, miner safety was ignored, and poor oversight from the government regulators. The lack of action the Westray managers, provincial bureaucrats, and politicians was pointed out in this report. The mine's ventilation system was inadequate. Westray management repeated safety regulation violations. The Department of Labor failed to enforce safety regulations. This report was 800 pages long and had a list of recommendations that the Nova Scotia government accepted all of. Some of these recommendations were improved training for the miners, independent review of Provincial's occupational health and safety branch, and legislation that will hold corporate executives liable for the workplace safety. So after the disaster, the RCMP announced charges of manslaughter and criminal negligence causing death against Carrata Resources Incorporated and two other mine managers on April 20th, 1993. Charges were dropped on June 30th, 1997 after reviewing the evidence which prosecutors believed no reasonable chance of conviction. In 2002, the federal government introduced Bill C-45, which established a legal duty to who directs the work of others to ensure safety of workers in public. Sections in the Criminal Code of Canada corporation representatives can now be criminally charged.